everyone, this is Gilbert Gelada. I'm talking to you here from Private Corporate Counsel, downtown Orlando. This is Tufts On Tax, where all your tax questions and answers are right here with Mr. T. Scott Tufts. When it comes to taxes and tax law, he is the expert and the master. You can always call him at 877-647-7887. Again, that number is 877-647-7887. You can see it on the screen if you're watching YouTube, or you can use 407 instead of 877, and it would be the same number, 407-647-7887. You can also email him at stufts@pcc.law. That's stufts@pcc.law. T. Scott Tufts, how are you today?
Hey, good to be with you.
Good to be with you too. And today we are first in a different location in the office here, looking at Lake Eola, lovely Lake Eola in Orlando, downtown Orlando. And we are talking about update on worker classification. So if you can clarify a bit about that.
Yeah, so worker classification means your disputes that exist in the law between an independent contractor and an employee. And so in the analysis of that, it depends the context. What context is that occurring? Is that occurring in a battle with the state and unemployment compensation? Is it dealing with overtime? Is it dealing with federal law? What kind of law? Is it an IRS issue? Those type of breakdowns. Is it a dispute dispute between parties? So it's important to know the context from which it occurs. And then there's very interesting things that happen that folks out there need to know about.
What other things?
So a recent case kind of highlights the point, and this is a case that involves a new case out of Virginia that caught my eye. It's Amazon Logistics, Inc. v. Virginia Employment Commission. It's a case involving the Virginia Employment Commission having a finding that certain delivery drivers, I guess known as flex drivers, with the Amazon Logistics Company, whether they were misclassified as a independent contractor rather than an employee, and what are the standards used by the agency in making that determination.
Oh, that's interesting.
Yeah, so what we talk about here is, and of course there are a lot of drivers out there and whatnot, and what I want the audience to understand is that if just one worker is being looked at and they make a decision, the agency oftentimes will say, and you company have not only misclassified one worker, you've misclassified all similarly situated workers. So in other words, the finding is critical for a company because it's not isolated generally to one worker. It might be a group of workers. So with drivers, there's just a lot of concern out there with when and how does a situation arise where a driver would be, or a delivery driver, or whoever it is, can be reclassified under the law. And now let's kind of back up. Many of our folks in the current economy, the gig economy as we call it, might say, wait a minute, I've heard about this ABC test, and that's how they test. And that by the moniker would be that there's a 3-part test out there in many states that many folks know about, all right? But not all states and in not all contexts is the ABC test applied, okay? And most importantly, this is a long-standing battle of how do you know? What's the test? And a long time ago, Gilbert, in 1987, the IRS issued what was famously called the 20-factor test. And it's actually under a revenue ruling, 87-41. And the IRS issued these 20 factors. And when I came out into practice many years ago, the 20-factor test was viewed as kind of the test, all right? However, what became apparent in the 90s was that this test, this 20 factors, and again, I won't list them now, but let's say there are 20 factors that they kind of say, okay, let's look at them, and depending on how they come out, we'll figure that out, right? So the 20 factor test might be things like instructions, a continuing relationship. And so what are we talking about there? Instructions. A worker who is required to comply with other person's instructions about when, where, and how he or she is to work is ordinarily an employee. This control factor is present if the person or persons for whom the services are performed have the right to require compliance with instructions. So in other words, they're equating control with the level of instructions given, right? Makes sense.
Yeah.
And even if not exercise, it's your right to exercise it. All right, so that's one of the factors. Another one that the court looked at in the case of these flex drivers.
So these are just to narrow down to make sure to confirm that either they are contractors or they're working for the company.
That's right, and working for the company. Well, a contractor works for the company.
Yeah,
but the idea is whether they're an employee, right?
Yeah, that's what I meant.
And then the key here is these are factors. So how many factors? Like, is it I have 11 and you have 9, and I win? Or is it what about weighting them? What happens if I say, yeah, but the 3 most important factors in this case are these?
Okay.
And who's saying that?
The government? The IRS?
Yeah. So if I'm an agency and I come in and say, well, we have one factor, but it's the most important factor.
Oh, that's another.
And you say I have 19 others, and they say, yeah, but only one matters. How does that work? And I'm giving an exaggerated example, but to point out, well, how you weigh them? How do you weigh them? Is it a mathematical test? And some of these factors, as you'll see, just kind of don't apply in the situation, or they're not easily applied. So, for example, with the flex drivers, they were looking at continuing relationship. A continuing relationship between the worker and the person or persons for whom the services are performed indicates that this is an employee-employer relationship. A continuing relationship may exist where the work is performed at frequently recurring, although irregular, intervals. So what are they looking at there? Are you just continuing to work for someone? Well, that would be like employment. You work until you're fired or you quit, right?
Exactly.
Whereas a contract is kind of a particular job, particular purpose.
On a particular gig, for
example. Particular thing, right? Hey, I'm coming to you. I enter into a contract with you. I'm going to do X. I get the job done. I move on.
Exactly.
Right? I paint your house. I'm not going to keep painting your house. Unless I do it wrong, but right, I'm hired for the job. You wouldn't say I'm your employee, right? But if I'm a handyman and I stick around all the time and I work for you and whatever, at some point I cross that threshold, right? So another one, factor 7 of the so-called 20-factor test, the establishment of set hours of work by the person or persons for whom the services are performed is a factor indicating control, right? And then let's try another one. Full-time required, factor 8 under the 20-factor test. If the worker must devote substantially full-time to the business of the person or persons for whom the services are performed,
that means
such persons have control over the amount of time the worker spends working and impliedly restrict the worker from other gainful work. An independent contractor, on the other hand, is free to work when and for whom he or she chooses. Make sense?
Yeah.
Okay. And then another factor is factor 9. They look at it. Doing work on the employer's premises. If the work is performed on the premises of the person or person on whom the services are performed, that factor suggests control over the worker, especially if the work could be done elsewhere. Work done off the premises of the person or persons receiving the services, such as at the office of the worker, indicates freedom, some freedom from control.
That's interesting because during the pandemic
Yep.
until now,
Yep.
a lot of people working for companies and working remotely. So how do you look at that? Do they adjust this or
For the times?
Yeah.
Yeah. So, and then how have the employers adjusted to control the remote workers, right? With how can that, how is that done, right? Because in the pandemic, if you had to open up and adjust to a new way of working, right? How in the current age are controls done, right? If the premise is that employers and employees have stricter policies and control the worker, how do you control a worker who's remote, right? And so that gets into how what I would look at, Gilbert, there is how did the remote situation translate into, let's say, before the pandemic, right? What were the rules and conditions on working remotely, right? And then from there, you look at once the remote worker has kind of taken off, how have employers reacted to institute controls, and then compare that to maybe remote workers who are independent. And you would go back to you're remote, but you're checking in and clocking in.
True. Yeah,
right?
There's a way of having control even though you're not on.
Yeah, I might remote in and press a button and clock in.
Yeah,
right?
or logging in the server or something like that.
Correct. Another factor that they look at, just to kind of give examples here, is factor 10, order of sequence set. If a worker must perform services in the order or sequence set by the person for whom the services are performed, that factor shows that the worker is not free to follow the worker's own pattern of work, but must follow the established routines and schedules of the person or persons for whom the services are performed. Often, because of the nature of the occupation, the person or persons for whom the services are performed do not set the order of the services or set the order infrequently. It is sufficient to show control, however, if such person or persons retain the right to do so. So if you think about that, kind of regimenting how the work is to be done, right? And then if you go further, there's factor 15, significant investment. If the worker invests in facilities that are used by the worker in performing services and are not typically maintained by employees, such as the maintenance of the office rented at fair value from an unrelated party, that factor tends to indicate that the worker is an independent contractor. On the other hand, lack of investment in facilities indicates dependence on the person or persons for whom the services are performed for such facility, are performed for such facilities and indicate an employer-employee relationship. So again, are you investing in your own business, or are you totally dependent on the employer, right? And then 19, right to discharge. The right to discharge a worker is a factor indicating the worker is an employee, and the person possessing that right is an employer. The employer exercises control through the threat of dismissal, which causes the worker to obey the employer's instructions. In other words, kind of that carrot over you. An independent contractor, on the other hand, cannot be fired so long as the independent contractor produces a result that meets the contract specifications. So you see what's going on there? You have a specific job to do. You're performing it. The person for whom you're performing the services isn't likely to want to breach that contract, whereas employment relationships are much more, right to hire and fire, right?
When this case happened?
So this case is discussing these 20 factors from the 80s. On September 26, 2023 is the decision.
Oh, wow.
And what's interesting is Amazon on appeal argued that the use by the Virginia Employment Commission of the 20 factors was improper. How they applied it and the fact that they were using it.
And that issue happened just in that state?
Yes.
It doesn't apply for other states?
Right, because this is the Virginia Employment Commission dealing with the unemployment claim by a driver, right? So the driver files for unemployment, right? And the Employment Commission says, wait, the company, right? Because the company would object and say he or she was an independent contractor. We don't owe unemployment, right?
Touchy.
Right. So you have an independent contractor filing for unemployment claims, and the company has to come in and say independent contractor, and the agency comes along and does it. But here's the rub. Here's what we know, though. Let's back up. When we're talking about IRS and the federal tax law and the federal payroll, okay? Remember I said context matters. We're talking about the common law. We're not talking about other laws that are remedial in nature. What do I mean by remedial? I mean that the benefit of the doubt goes in favor of employment because let's say it's 10 factors. It's a close call.
Yeah.
Right? Well, if the law is written to be aggressively pursuing something or remedial in nature, then tie may go to the government and the agency on the issue. But if it's not remedial in nature, the law, the context, then maybe the benefit of the doubt should go in a close call to the freedom of contract. Right? So this is kind of the important thing here. And it's kind of missed in the Virginia case because what I noticed when I went through the opinion, and again, this is just an observation I would make, that they were picking out factors that kind of emphasize how they believe control existed to find employment.
Yeah.
But kind of overlooked a little bit is the fact that the court says the following, but this court is not bound by the commission's interpretation of the 20 factors, meaning the commission agency applies the factors, you disagree, and then you go to court, you appeal the commission's findings because you say they got the factors wrong. Got it? You know, you said you had this many factors, you're the agency. I say I had so many others. The agency says we win, you lose. You appeal it and you go to a court. This court comes in and says, hey, look, just to be clear, we're not bound by what the agency has done here. Okay? Right? But then they say this, interpretation of the factors presents a question of law that we review de novo. That means they take a fresh look at it. So the good news for folks out there is the court will do an independent review of the test, whatever the proper test is. All right? Now, here's what they say, though. In our review of the law, we are guided by the following principles. The meaning of employment in the unemployment compensation context is controlled by statute. The act is to be liberally construed to affect its beneficent purpose, and in borderline cases, employment should be found to exist. Exemptions in the act should be strictly construed against the alleged employer, the rule requiring liberal construction in favor of the taxpayer not being applicable. So, why am I mentioning this? Because factors and applying it in close calls, the context matters. In the IRS context, the IRS has gotten away from the 20 factors and created a categories of evidence approach. Gilbert, 3 main categories: financial, behavior, and the intent of the parties. Got it? They don't apply the 20 factors. All right? But everybody knows about them, but they don't apply them. They apply a categories of evidence approach. They went to this in the 90s. Okay? Ask yourself, why? Well, they did because the Supreme Court decided a case called Darden, Nationwide Insurance, something, national, whatever the case, but Darden was the case, D-A-R-D-E-N. And that case basically said that the common law, right, requires a neutral approach, right, where the intent of the parties matters. One of the things that you'll notice is the 20-factor test did not include as a factor the intent of the parties. Got it? So we do a contract together. We say it's independent contractor. Does that have any weight under the 20 factors? No.
No.
But it does in the common law. And therefore, in the 90s, the IRS internally recognized, and I had some cases that did this too, where we actually established that the intent does matter. So then that's how it got into categories of evidence. Because at the IRS level, there's this thing called Section 530. And it's a special remedial statute in favor of taxpayer companies in the case of a benefit of the doubt, if you meet its criteria. So they have what we call a safe harbor, a place to go where it says, look, if it's a close call, the government is prohibited from reclassifying potentially misclassified workers because it was a close call, because you acted in good faith in making that decision. Got it? So the point being is, arguably at the IRS level, the remedial aspect of the law is actually in favor of companies. Okay?
Of course.
But not so fast. But only if, okay, they meet this Section 530 provisions that have a number of criteria to them. So it's a little tricky. It's not just generally tie goes to the employer. It's if the employer, a purported employer, acted in good faith in making the determination of worker status. In that case, then the tie would go to the company. But remember, it also requires the analysis, right? The categories of evidence approach, they're very broad, concerning all kinds of input evidence of financial, behavioral, and then also the intent of the parties. Okay? Now, the intent of the parties is more than just your written contract. It would be how you acted, how, what statements of intent. So my point is folks got to get, again, Gilbert, we say time and time again on this show that the key is that you got to do a deeper dive. You can't just fly at the surface. You got to dig down deep and get into these laws so that you know that there are little gotchas and niches and things like this. And here's a great example of it, where is the context that you're talking about an unemployment matter, a tax matter? Because here's the crazy thing. You can be an employee in one context and an independent contractor in another. And we're not even getting into other, you notice you say worker. What about lease arrangements? What about partners and partnerships and all this? The relationships are not always employer-employee, independent contractor, company. There can be many other titles or headings. And so it is a much more involved inquiry. But what I want to absolutely show folks is that here you have a state case with a state adopting in the unemployment context some old factors, 20 factors that the IRS doesn't even use anymore. And the commission says, okay, that's fine. We use them as a guide and so forth. But the key is it's remedial. So they're essentially, in Virginia, they're applying it in the way the IRS used to back in the 80s before Darden came in and said the common law is not to be construed that way. Got it? So very interesting case.
Now going back on the intent, when you said the intent, so let's say they had a contract and it says they are a 1099, going back to our forms.
Yes. There you go. See, Gilbert, what I like is you're catching on. You're just not over there sleeping. You're catching on, and
by season 10, I'll be really an expert.
Okay. See, that's something to look forward to. So yes, 1099. You were saying 1099? Yes.
10 that will make them a contractor.
Right.
They're not an employee.
Now let's be clear. 1099 NEC. Because it used to be just one 1099 form. But believe it or not, there's a 1099 miscellaneous form and a 1099 NEC form that they brought back from many years ago. So NEC standing for non-employee compensation.
But if it was miscellaneous?
Well, it wouldn't be miscellaneous.
Okay.
Well, but it could be, yes. Good point. If the 1099 NEC form is strictly for non-employee compensation, then you are right. All other purposes for the form that used to exist in one form are separated out. Absolutely. So the use of a 1099 NEC form.
So Amazon didn't think of having that there?
No. What we're saying.
I'm not familiar with the case.
All right. No. But I assume, I don't know, but I'm assuming they issued 1099s.
Then.
But it's a state case where the 1099 and the intent of the parties don't matter because they're using 87-41, which is the 20 factor. Remember what I said? The 20 factors don't have it in it, the intent. But you're right on it. The filing of the 1099 alone, because think about it. You get a 1099. Did you object to it? Right? If you're sitting there saying, wait, I'm an employee. Well, you didn't object to the 1099 when you got it, right?
Exactly.
So that would show that the parties are in simpatico, right? You think?
That falls also on Uber drivers?
Yeah.
So that's
well, Uber's, and so the ABC tests out in California and other places really got into it, and I think they carved some special laws out. We can deal with that on another episode. That's very interesting. But those of the Ubers and other such drivers that are out there, they really were going at it. Another one was the Federal Express, some of their workers. That's right. So, and what can happen there is you start to get, with a large company with a large number of workers, it can be a big time issue. Microsoft had it many years ago, and what can happen is the impact is so great that they decide to legislate some kind of fix in there to avoid the calamity that would come from a reclassification. Not so lucky if you're not the maybe those larger ones that can get the legislative change. But yeah, we'll look at that. We'll take a peek at what the current situation is for those kinds of drivers. But
different times and different laws should apply.
Yeah, that's another great point. You hit it real quick about, well, what about remote workers and what about the change in the economy? Things aren't the same. So, that's another interesting question. If you're looking at a case from 20 years ago and it's applying the law as it existed then, does it translate to today?
Exactly.
In the way that we operate businesses.
How often do they have to go revisit these
Exactly.
things?
And really the question is how is the right to control really manifests itself in the current environment?
Correct. And technology.
Yeah, because do you have a buzzer on your phone? I mean, does your computer shut down because you're not timely, and therefore you don't get to work for the day and it's over? Is there more flexibility? Is there you check in when you want to, right? I mean, many questions. So, but great topic again. That case, Gilbert, for our audience is Amazon Logistics v. Virginia Employment Commission, September 26, 2023, and 892 Southeastern 2nd, 331 for those who have the legal resources. And again, the 20-factor test set out in Revenue Ruling 87-41, and this was a Virginia interpretation of Virginia statute, and very interesting because what our audience should conclude from this is be careful with the context. Know the context, know the law that is at issue. Don't jump to any conclusions. Is it common law where there's no remedial purpose, or is it a Fair Labor Standards Act or some other federal law or state law that has a remedial purpose to it that will turn the close the close call cases in favor of the agency? So you have to try even harder to overcome that effort. You know what I'm saying?
Yes.
And then for our tax folks out there, for these situations, you're looking at the Section 530, which is a very helpful safe harbor, but that it's got a lot of restrictions on it. It's remedial in nature. That should work as a bulwark against an effort to aggressively reclassify your workers, but only if you meet its criteria. Okay? And you were mentioning 1099. The Section 530 is very clear. You have to have compliance with the form filing requirements if they're required. So there are situations where maybe a 1099 didn't have to get filed, and therefore that shouldn't kick you out of that safe harbor relief. But anyway, again, context matters when you have a worker classification situation.
Yeah, you heard him, folks. Be careful just for you in the future. And also, employers should be also careful when they're hiring employees or if they're contractors. You can call Mr. T. Scott Tufts at 877-647-7887. Again, that number is 877-647-7887. You can also reach him on a 407 area code. You can email him at stufts@pcc.law. That's stufts@pcc.law. You can visit the website at privatecorporatecounsel.com, and you have a wonderful day. Take care.